Good afternoon, everybody. Welcome to, this is what, the second in our speaker series this year in this class, Law, Politics, and the Media. And we're delighted to have our guests with us, joining our students in the class. We're going to hear today from David Weisenfeld, who is, among other things, a graduate of the Syracuse University College of Law. He has covered the U.S. Supreme Court since 1998, and he also serves as editor-in-chief of Lawcast, which is a nationwide NPR-style audio legal news service. And I've had the pleasure of working with David on several Lawcast publications, editions. I mean, my field, as you know, is patent law, and I'm always impressed with David's facility with all of the different areas that he covers. It's as if he's an expert on every single subject it's very impressive, because when he enlists me to work with him on a Lawcast, I work hard to get ready for the hour-long broadcast, and he's always at least as ready, if not more prepared than I am on the subject. He has reported on a host of high-profile Supreme Court decisions, again, including landmark rulings relating to the entire spectrum of constitutional and other kinds of issues that come before the court. As I said, he co-anchors all of the 10 companies' newscasts, supervises its programming content. He has attended, as I mentioned at the class earlier, more than 200 oral arguments at the nation's highest court. He has interviewed the former U.S. Solicitors Ted Olson, Seth Waxman, and Walter Dellinger, as well as other leading Supreme Court advocates. He's received numerous honors along the way. He's built quite a very interesting career for himself, and we are very proud here at the College of Law to call him one of our own. He's here today to speak on the topic Blue or Red, an inside look at the politics of the Supreme Court. We'll hear from him for approximately 40 minutes, and then we'll make sure we have some time for questions and audience participation, and we'll wrap up at around 5 o'clock and recess and enjoy a reception. So thank you very much. Thank you, David, for being here. Please welcome our speaker.
Thank you very much, Professor Dolak. Thanks for that very warm introduction. It's really wonderful to be here. I should say, by way of beginning, that I was here for the all-time 3 snowiest winters in Syracuse history, back to back to back in the early 90s, including one that was 190 inches of snow. So I wanted to wait until that record was broken, and I hear that we're well on our way if we haven't broken it already. But anyway, I wanted to talk about one of my passions, which of course is the Supreme Court. I've been covering it since 1998. I've had a chance to see a lot of really fascinating arguments in a variety of areas, and some perhaps that you've never heard of, but were nonetheless quite interesting from a legal standpoint. One of the things that makes covering the Supreme Court so interesting, before I get into the politics of it, is the fact that you hear so little about it and that there's no cameras. You can't see it. It's not like the Senate or the House, where you can watch proceedings on TV. You can't do that with the Supreme Court. There's no radio either. So that makes the public very much dependent on people like myself and others who are in the press gallery to kind of give a blow-by-blow account of what's going on. Now, certainly, you can get same-day argument transcripts from the Supreme Court's website, which is supremecourtus.gov, but it's almost kind of like getting a Cliff Notes version, or hearing about a ball game without actually seeing it from your friend. It certainly gives you all the words, gives you all the questions, but it doesn't necessarily tell you that Justice Sotomayor was glancing over right at Justice Scalia as she asked the question. It doesn't tell you that Chief Justice Roberts' voice might have been dripping with sarcasm when he made a particular comment to an advocate. So you really kind of need to be there to get the flavor. Perhaps someday, maybe there will be televised proceedings at the Supreme Court, but I don't think that day is going to be anytime soon. Just to give you a sense, a comment that I noted with some of the people that I met with at lunch, Justice Souter, who recently retired, once said there'll be cameras at the Supreme Court when they roll over my dead body. So that kind of gives you a sense of where the court's thinking is in terms of when we'll see cameras in the courtroom. Now, as you know, there's huge stakes involved in a lot of these cases that come up. We saw Citizens United just a year ago. I'm sure many of you remember that quite well with the State of the Union and the exchange between, or not really an exchange, but President Obama chiding the court and Justice Alito mouthing the words, "not true." Many other big cases with some political components as well. But that's why I want to really start and go back to the very beginning with the court, and that's how these justices get to the court, and it's the confirmation hearings. And that's why I say blue or red, because really we have a lot of very fascinating battles that we've seen over the last 25 years in confirmation hearings and some behind-the-scenes maneuvering. As I'm sure you all know, we've had 2 confirmation hearings just in the last little over 20 months or so. Did anybody, just by show of hands, get to see any of those with Justice Kagan or Justice Sotomayor? Okay, a few. Did anybody get anything out of it from the questions? Probably not. It ends up becoming sort of a dog and pony show, a little bit, if you will, with senators on both sides trying to get at the potential nominee with their particular views and their particular interests. But you don't really get at where the justices might stand, in part because most of the time they very successfully and deftly avoid answering questions about where they might stand on a particular case. They don't really want to show their hand, so to speak. And if they do, it might open them up to potentially more criticism and more opposition. So the result is that they tend to say very little. Some of the nominees who've been most successful have been some of those who've said the least. So that's kind of where we're at with the confirmation hearings. Now, one of the hearings that I want to start with and talk about, and it came up for those who may have read in the Lori Ringhand article, and we're going to take us back to 1986 when Justice Scalia was nominated to the court, and look at that in tandem with Judge Robert Bork's failed nomination just 1 year later. Justice Scalia, as you undoubtedly know, a staunch conservative, has a strict constructionalist judicial philosophy of relying on the text of what's in the Constitution, and is also a very big believer in states' rights and the concept of originalism. Despite that, he sailed through 98-0. Now, I would submit that Mother Teresa probably couldn't get 98 votes if she were up for nomination to the court today. Now, not being a lawyer might hurt a little bit, but nonetheless, we've become much more divided even than we were 25 years or so ago. And yet he got 98 votes. Now, why is that? Well, 3 good reasons why. Number one, you have to think about what's going on in the country at the time. President Reagan was extremely popular. In fact, he was nearing the apex of his popularity. Also, Scalia was the first Italian-American ever to be nominated to the Supreme Court, which certainly was a very popular thing. He was a forerunner of sorts. So you couple those 2 things together and put them with the fact that Scalia had a sterling academic record. He'd been on the D.C. Circuit for 4 years, and he sails through, gets 98 votes. Well, now let's go 1 year further into the future. Robert Bork, who in fact was the finalist when Scalia was picked a year earlier, gets nominated by President Reagan. Now, does anyone remember what was going on in the country in 1987? Iran-Contra. That's right. President Reagan's popularity was dropping like a stone. Also, in fact, those hearings, and I still remember them quite well, were going on for 3 or 4 weeks throughout the summer of '87. And that was only about 6 weeks or so before Bork's confirmation hearings took place. So we have Reagan's popularity dropping. We have Iran-Contra. The Democrats have also made gains in the Senate. Now, certainly that doesn't explain how a 98-0 vote switches to how Bork's nomination went, but nonetheless, those three things were all factors. But I would submit to you all that those weren't the biggest factors. They certainly were underlying factors, but they weren't even close to the most important thing in terms of how somebody gets on the court. And that has to do with the politics of who you're replacing. Antonin Scalia, 1 year earlier, is replacing Warren Burger, essentially, because he's taking the spot of Justice Rehnquist, who had been promoted from Associate Justice to Chief Justice. So although Burger and Scalia are not precisely identical in terms of their philosophies, Scalia a little bit more conservative, really it's not going to have a huge shift in terms of the overall nature of the Supreme Court. 1 year later, by contrast, Robert Bork is replacing Lewis Powell. Now, Lewis Powell, although he had been a Nixon appointee, was really at the center of the court. You might say he was the Sandra Day O'Connor of his time. In fact, he was a mentor to O'Connor on the court. He was really the fulcrum. Oftentimes, cases were decided 5-4, and the fifth vote was usually Powell. Often he voted with the conservatives, but by no means always, especially on social issues. So there were many people in the Senate who knew full well that if a staunch conservative were to take the spot of Powell, that's going to shift the court quite a bit to the right. And that's why you see a lot of opposition. If Bork gets nominated 1 year earlier and Scalia gets nominated 1 year later, perhaps Bork is on the court today. Scalia might be as well, but we don't know. But that's why I mentioned, and I'm going to get to some other examples as well, but one of the most important things in terms of politics and the Supreme Court is who you're replacing. Which spot are you taking? People in the Senate are always conscious of how is this going to shift the court. So that's why that is such an important factor. Another important factor is, frankly, how much you've written. And I'm going to get to this with the more recent nominations as well. Judge Bork and Justice Scalia each served together on the D.C. Circuit, and yet Judge Bork had been there for a couple of more years only, but he had written many more opinions, and some on some controversial topics. Scalia, although his views are well known now, the full extent was not quite known at the time. There was much more written evidence with Bork, and that ended up coming back to bite him, if you will. And there have been lessons drawn from this that we can see in terms of who's nominated right up to the present time. But that's why that, coupled with who is being replaced, is why you see two judges nominated just 1 year apart and trying to tell the difference between them, almost a bit like trying to tell the difference between what, say, two of the Kardashian sisters might look like, was pretty hard. And yet, one guy gets 98 votes, the other loses 58-42. He's the only nominee not to make it to the Supreme Court who went to a vote since the early 1970s. Fast forward now to some recent nominations. And I will give equal time. I'm definitely going to get to the Democratic ones as well. But going a little bit in chronological order, I want to talk about Chief Justice Roberts and Justice Alito. Because although both do make it to the Supreme Court, of course, we see this same theme again that I'm describing with what we saw with Bork and Scalia. And by that, what I mean by that is Chief Justice Roberts gets confirmed 78-22. I would argue that that's almost like 98-0 in the world of 1986. As divided and partisan as the Senate has become, getting 78 votes was quite impressive. And Roberts certainly had a lot to support him. Very impressive background, worked in the Reagan administration, one of the foremost appellate advocates, had argued 39 cases before the Supreme Court. That was more than anyone else on the court had ever argued in their careers combined prior to joining the Supreme Court. So certainly a stellar nominee, very telegenic, and he gets through with 78 votes, very little opposition. Although interestingly, one of the people who was among the 22 was President Obama. But anyway, just a few months later, and this illustrates my point even more, just literally 2 or 3 months later, we have another confirmation hearing with Justice Alito. Justice Alito and Chief Justice Roberts, very similar backgrounds, again, much like Bork and Scalia, like this. Now, I wouldn't describe either of them as originalists, like Scalia, but certainly both conservative scholars, similar backgrounds, and yet Alito, just a couple months later, gets 58 votes, gets confirmed, but narrowly averts a filibuster. I don't know if anybody remembers this, but his wife ran out of the room crying because she thought he was being treated so unfairly during the confirmation hearings. And just the overall tenor of the questions tended to be a lot more hostile to Alito than it was to Roberts. Anybody have any ideas as to why that might have been? Well, a couple of good reasons. One has to do with what they had written. While their backgrounds were in many ways similar, both Reagan administration lawyers, both highly distinguished in practice, Judge Alito had been a Third Circuit judge for 15 years. Well, that leaves a lot of time to write a lot of opinions on a lot of social issues and a lot of the controversial ones, biggest ones of the day. And certainly Alito had done that, and there was a lot to parse through. By contrast, the Chief Justice had been a D.C. Circuit judge, but only for a little under 2 years. So certainly not nearly the voluminous record that we see with Justice Alito. But again, the most important thing, those writings certainly were important, but an even more critical factor in what kind of drives some of the opposition is who they're replacing. Chief Justice Roberts is taking the spot of his mentor, who he once clerked for, Chief Justice Rehnquist. Very similar in their views. In contrast, Justice Alito is taking the spot of Sandra Day O'Connor, who was retiring. Much like her mentor, Justice Powell, 20-some years before, Sandra Day O'Connor is at the center of the court. Now, the center of the court in 2006 is a little bit more to the right than it was in 1986, but nonetheless, she is providing the fifth vote on a host of issues. Sometimes that's with the conservatives, as in suits against states for employment discrimination and other issues. Sometimes it's with the liberal to moderate wing, such as the famed 2003 affirmative action case of Grutter versus Bollinger. But she is really at the center and writing a ton of those opinions. So if she's going to be replaced by Sam Alito, that's going to shift the court. So that's why you saw Democrats and some liberal moderates, but Republicans, but mostly Democrats, holding their fire with Roberts, but really taking a fight with the Alito nomination. So I encourage you always to think when there's a nomination about how does this shift the court vis-a-vis the person being named and who they're replacing. Now, some of you might have noticed I left a name out there. Does anyone remember the name of Harriet Miers? Yes, okay, I see some nods. Well, Harriet Miers was the person, for those who don't recall, who was the original nominee for that seat, for Sandra Day O'Connor. In fact, had she gone through, her confirmation hearing might have been just a few weeks after the hearing for the Chief Justice. But Miers faces some opposition, really from all quarters, but ironically, and this is a somewhat new development in our history of Supreme Court nominations, she gets a lot of her opposition from her own side, from the Republicans. Certainly there was some when she was nominated from the Democrats, but much more from the other side. Now there's a couple of reasons for that that you might want to think about. One has to do with the fact, and this has to do with litmus tests. You've probably heard that expression. Used to be the litmus test was where somebody stood on abortion. And certainly that is still a factor, but it's really become much broader than that and brought many other issues into the fold. Miers had stated that she was pro-life, but that didn't satisfy a number of social conservatives and people to the right in the Republican Party, and so she drew a lot of opposition. People weren't really sure where she stood because she hadn't been a judge. She didn't have writings. So in contrast to some other nominations, here's a situation where somebody who doesn't have writings is actually hurting them a bit. And in fact, she's forced to withdraw. Some of the early opposition on the Democratic side, though, was interesting. And the Democrats actually pulled back when they realized that, hey, the Republicans are attacking her, so let's just get out of the way and not say anything, so to speak. But they were upset. They were questioning her academic credentials. In some respects, regardless of whether you thought she was a good nominee, bad nominee, or indifferent, that might have been a little bit unfair as well. Because really, her credentials weren't so bad. She went to Southern Methodist University Law School, put her way through. She was the first ever woman to head the Dallas Bar Association. She was one of the leading female attorneys in Texas. And of course, she had worked in the Bush White House as his White House counsel. Now, certainly that became a political football a little bit as well, since she was seen as tied very closely to the president. But in terms of her academic background, you might want to think about the fact, is it really so bad, where she went to school? A lot of behind-the-scenes comments made about that, but do we want a Supreme Court where you need not apply if you only went to Harvard or Yale or Stanford? Do you want a Supreme Court where the only people who argue went to Harvard or Yale law schools? To a large extent, that's what we have. So in some respects, she might have brought some diversity. Whether she would have been a good justice or not, we'll never know. Some people think yes, many had their doubts. But one other point I'd bring up before I move on from her is that, Sandra Day O'Connor didn't have quite the resume of some of the other justices on the Supreme Court when she was named by President Reagan. And from my experiences covering the court, she was probably one of the 2 or 3 most impressive justices during an oral argument that I've ever had the experience of seeing. And yet she was a relatively little-known Arizona state legislator and Arizona state judge prior to becoming a Supreme Court justice. So it's hard to know how these people are going to grow and evolve when they're named to the court. Getting back to my point on litmus tests, we're starting to see a trend. I shouldn't even say starting. We're seeing even more of a trend of nominees who have been vetted to such a point that we feel like we know where they're going to stand on a particular issue. And Miers is perhaps a good example of that, because the person who comes in her stead is Justice Alito. And there was no doubt from his writings as to where he stood. And yet, once in a while, you get a surprise. One of the cries that came up during the time when Miers was chosen was "no more suitors." That was in reference to Justice David Souter, who just actually retired a year ago. He had been vouched for by Republicans in New Hampshire to the first President Bush and ended up being quite a bit more moderate than was expected. The same happened a couple of generations earlier with Earl Warren, perhaps the most famous member of the Supreme Court of the 20th century. He had been governor of California, never been a judge. President Eisenhower, one of his first acts was to name Earl Warren to the Supreme Court. Well, he later said, Eisenhower did, naming Earl Warren to the court was the biggest damn fool mistake I ever made. The reason he said that wasn't necessarily because Warren was a bad justice or bad Chief Justice, he wasn't, but because He certainly didn't hew the line that Eisenhower had thought he might. Now, let's talk a little bit about the most recent nominations. President Obama certainly, or the people around him at the least, took good notes about what happened with Roberts and Alito and some of the other nominations that we've seen. Because what we see with, and I'll talk a little bit more about Justice Kagan, because Justice Sotomayor is kind of in a different category, but with Justice Kagan, what you see is a nominee who has impeccable Democratic credentials, had been in the Clinton administration for many years, had been the president of Harvard, but she's never been a judge. Hadn't really practiced much. So it's a candidate who there isn't a lot to oppose. More importantly, she'd been Solicitor General. So she's already gone through the Senate confirmation process. So he's essentially saying to the Senate, here's someone you already confirmed and you did it just 11 months ago. So how do you then oppose her for the Supreme Court? Now, it was an interesting choice because there were some other candidates, and in fact, many other female candidates, including Diane Wood, who's a Seventh Circuit judge, who had sterling reputations and, like Justice Alito, had been judges for 10, 12, 15 years. But the reason that they weren't chosen, and Wood, by most accounts, and also from what I've heard, was the finalist who didn't get the knob, so to speak. But one of the reasons that she wasn't picked was because of those writings. And that kind of raises the question, is this what we're going to see going forward? Elena Kagan may turn out to be a great justice, maybe not, we don't know. But what we do know is that we've now had a couple of justices named to the court in recent years who either had never been judges or had been for only a very limited amount of time, or didn't have a lot of published writings, and yet are being named to the Supreme Court, ahead of some people who've written quite a bit, and we know where they stand. I suspect what we're going to see going forward is more of the latter, more choices like Kagan. Now, one thing to think about, people said, well, Kagan had never been a judge. You don't have to be a judge to be on the Supreme Court, of course. Actually, you don't even have to be a lawyer. But the trend had been in recent decades that we pretty much mostly chose judges. John Paul Stevens had been the last member of the Supreme Court who hadn't been a judge prior to joining the court. But now we see Kagan chosen, and it'll be interesting to see in the coming years if we see more choices like that. Certainly, it was a nomination that offered the chance for boldness, you might say, from the president, because he had 60 votes at the time in the Senate, but he did pass over a number of more liberal nominees to choose Kagan. Now, this brings me to another point that I want to tie in that I brought up before, and that is with shifts in the court and who you're replacing. Now, at first glance, you might say, well, Kagan's replacing John Paul Stevens. It's just as trading one vote for the other. They stand in pretty similar spot. Although Justice Stevens had been named by a Republican president, it was President Ford, a fairly liberal Republican, and Stevens ends up actually being the leader of the progressive wing on the Supreme Court. So you might say, well, that's not going to shift the court. But interestingly, in some unintended ways, it might this year. Now, what do I mean by that? Well, we're already seeing some examples of it. And you've probably heard the expression, I think it was Woody Allen who said 90% of life is showing up. Well, part of the problem with the Elena Kagan choice, with the first year anyway, is since she had been Solicitor General for the last year, she's recused herself from a large number of cases. Now, you have the option, it's really just at the discretion of the Supreme Court justice as to whether you hear a case or not, but Kagan has made the decision to recuse herself from all cases in which the Solicitor General's office signed the brief while she was heading that office. Well, what the result has been is that of the first 54 cases to come to the Supreme Court this year, Kagan sat out 26 of them. That's quite a big number. So what are you having? Well, we already saw one example of it from Professor Dolak's field, intellectual property. You've had a 4-4 tie in a big business case involving gray market goods this year. Might have been 5-4, but Kagan wasn't there. We have some other big cases coming up in the pipeline, including one that I just reported on a month or two ago involving a very controversial law in Arizona. Now, it's not the one that you might have heard about this past year involving their targeting of illegal immigrants. This one has to do with stripping the licenses of employers to do business in the state who had employed illegal immigrants if they failed to comply with the federal government's E-Verify process. Some have speculated that that case, the court could be evenly divided, 4-4. Justice Stevens would have probably provided that deciding vote against the law. Justice Kagan isn't there. She wasn't sitting. So certainly she was a safe choice, but at least in the short run this year, the court actually, you could see a slightly rightward shift simply by the fact that you're seeing a few close cases where we have 8 justices. And of course, if there's a tie, people know what happens. Case gets remanded, and if let's say it came from the Ninth Circuit, the Fourth Circuit, wherever it's come from, the appellant loses, so to speak, unless the Supreme Court says, let's re-argue it. But they very rarely do that. So sometimes the shifts come when you least expect them. Any questions, by the way, before I go forward on what I've said so far? Yes?
I was wondering if, given that the biggest factor is who you're replacing.
Yes.
Right? I know there are these other factors that matter. Why was it the case that, say, Obama didn't go for a more bold choice? You say Kagan's kind of a safe choice, and there was associated with the fact that she had been Solicitor General, but she wasn't going to tip the balance. Similarly, why did Bush go with Alito, who was, often called Scalito,
right?
Because he was thought to be so close to Scalia in his thinking. So a pretty conservative choice for what seems to be for a swing seat. So it seems like the actual choices made by the actual choices made by the presidents in those two contexts were non-strategic. If what you're saying is correct, that the single most important factor is who you're replacing. It seems like Obama should have been, gone bolder, and Bush should have gone more mild. It sounds like I'm describing roasts of coffee, right? But I mean,
it's a good point.
Why didn't they? If they know what you know and what we now know,
yes.
We listen to you. Why don't they behave differently?
Great quote. Great point. Many people have said, in fact, precisely bringing up that point, that President Obama should have gone bolder. Regardless of where you are politically, there's no denying that he would never have a better chance to have gotten a liberal on the court than went with that nomination. A couple of reasons, and they have to do, again, I think, with what's going on politically in the country. He'd have been in for a fight if he did that, and the reason being, if you go back just 1 year ago, Justice Sotomayor was nominated kind of during his honeymoon phase. Popularity was very high. Really hadn't been a whole lot of controversy yet in his term. Healthcare had been talked about. Wasn't really that far along. By the time Kagan gets named, healthcare has already gone through. A lot of controversy, a lot of talking on Fox and MSNBC, as I'm sure you well know. And I think those were factors. He's thinking, I can win this, but I'm going to have a heck of a fight if I pick someone on the left. And he's also thinking in the back of his mind, we don't know what the next opening is going to be. I have no reason to believe that Justice Kennedy would step down anytime soon. He's in good health. He loves the job. But were he to be the next opening, and you've already gone through one protracted fight, and now you're going to have an even bigger shift with the court if Obama wants to name that widely perceived Democratic justice. I think all of those are factors in his mind. Yeah.
This might, might be changing the hypothetical too much.
Sure.
But say Obama was in the same situation, but he was in the second term, so he didn't have re-election to worry about. Do you think that choice of Kagan, do you think that choice would have been more bold had he not had to worry about popular in that sense?
Yes. Yes, I think so. I think so. It's interesting, just one other point that could have been on his mind, but it's entirely possible that we're going to see another opening as early as this year. The reason I say that, and now this is speculation, but Ruth Bader Ginsburg has had a couple of bouts with cancer. It's in remission, but she lost her husband earlier this year. She has said she wants to stay on the court for still several more years, but she is 78. It's not, and also you have to take into account of where you are in the term, like you just alluded to the second term. Well, if you're going to get somebody through, it'll be a lot easier this spring or this summer than it will be next year, because next year we'll be in an election year. And then after the election, you don't know what will happen. So sometimes the justices take that into account, and they wait to retire until the elections occurred. That's why you saw when President Bush was reelected to his second term, not long after that, you had an opening with O'Connor. Obviously, one was unanticipated. Rehnquist died. We can't anticipate that, of course. But a lot of it has to do with not only how the court's going to shift, but the timing. And timing, as you note, can be everything. I want to talk a little bit, before I wrap up, about judicial philosophy. I mentioned at the top with Justice Scalia about originalism. On the left, you see kind of a different view of the Constitution as more of an evolving document, and some rights can be inferred. So certainly all 9 justices have judicial philosophies. They're not solely governed by politics. They have their views as to how the Constitution should be interpreted. And they use those views, and you can see trends in how their views operate with their decisions. However, there's a couple of examples I want to leave you with where politics definitely has played a factor in how a case comes out. And this is true wherever you are on the spectrum. The most important of those cases is Bush versus Gore. I'm sure everybody remembers that one. Now, you might find it interesting. I know that decision has been widely parsed, much criticized by some, but I would make the point today that actually, if you look at that decision philosophically, all 9 justices voted against their own stated philosophies. What do I mean by that? Well, in 2000, that same year, earlier in the year, there were a host of cases that went before the Supreme Court involving the issue of states' rights, the right of employees to sue a state, the right of other private individuals to sue a state in civil court. There were, I think, 4 cases in all in 1999 and 2000 that came up involving that issue. In all 4 cases, the result was a 5-4 victory, insulating the states from being sued. Well, fast forward to the 2000 election, and in all those cases I mentioned, it was the 5 conservatives in the majority. Well, with the Florida recount, the Florida Supreme Court had said, let's let the recount go forward, right? And yet, the 5 justices who had voted in favor of states' rights in all of the other cases said, well, no, we're not going to defer to what the Florida Supreme Court said here, and they stopped the recount. But that's not just to single them out, because on the other side, the 4 moderate to liberal justices all consistently had voted in favor of a little bit broader deference to the federal government whenever there's a conflict between federal law and state law, we're going to apply preemption principles broadly. And yet here's a situation, and in fact, that's how they had voted in dissent in all of those cases. They would have allowed those lawsuits to go forward against states. And yet those same 4 justices now are saying, no, let's defer to the Florida Supreme Court. We have to defer to the state's right and the state court's wisdom in this case. So that you have an interesting dichotomy there. And that's something that we see again more recently with the Citizens United case, which allowed, basically had to do with corporate speech rights and saying that corporations have a right to free speech. And you see some justices voting the opposite of what they've voted in other free speech cases. Now, this isn't to say that the justices are just political pawns. They're not. And it's not, that would be a gross oversimplification. But my only point is that you do have a handful of cases where the politics come into play. Yes, they have their philosophies, but sometimes these cases that have so much attention, the justices can't help but be influenced by what's going on in the world. And certainly I think those are 2 examples of it there. Now I'll throw it open to questions in just a minute or 2, but I just want to give you guys a sense of what's coming up at the Supreme Court, because you might be wondering. This term is kind of the lull before the storm, so to speak. There's some interesting cases this term, including the largest ever sex discrimination suit in the nation's history against Walmart. Includes up to 1.5 million female employees of Walmart and former employees. Also have a case involving the sale of violent video games to minors and whether California can ban them. Also a case that could limit the pharmaceutical industry's exposure to civil lawsuits of all sorts. So some important cases to be sure, but I don't think you'll be seeing them at the top of the New York Times anytime soon. Those you might, but not too many others. But a few practitioners that I've spoken with have said that next year or the year after, you potentially could be looking at the term of the century, because we have a few things lurking in the wings that are stealthily moving their way up the court system. Anyone have any thoughts as to what they are? Healthcare, that's 1. Gay marriage is 2. Immigration is 3. Boy, you guys are good. All 3 of those, and just to throw out a 4th, we still have some terrorism issues and the power of the government and how much deference the executive is entitled to. So all of those issues could be coming to the court, and they could be coming in the same term. It might even be next term. Have to see how that plays out. So with that said, it's been an honor to speak to all of you today. If anyone has any questions, and certainly I don't want to limit it to what I talked about, even if you have questions about what it's like covering the court, I'm happy to answer them for as long as you like. Thanks. Yes, sir.
What do you think is going to happen with Common Cause's push against Justice Thomas?
You know, at the end of the day, I think probably not a lot. Because like I was touching on earlier, it is the justice's own decision whether you recuse or don't recuse in a particular case. Now, with the common, I assume you're referring to the trip to Palm Springs. Is that what you?
Well, that's one of the things. The
Right.
other is his failure to disclose his wife's income on his report.
Yes, yes. I suspect it will be a story, and you'll hear about it, and he's going to get some criticism for it. But at the end of the day, I don't think that much will come of it. Yes?
Thinking about 6 or 7 years ago, I'm just curious to hear your view of some of the whole body in the Senate as opposed to just the Judiciary Committee, some of the political strategies and tactics that, I mean, I think of like Miguel Estrada, and I think Charlie Pickering, a couple of those other nominees of Bush in like the mid-2000s. And sort of, I guess it was the threat by Democrats, I think they were still a minority then in the Senate, but like the threat to filibuster. Just curious to hear your view of how effective you think they might be those political strategies outside of just the confirmation hearings themselves?
You know, it's kind of a scorched earth philosophy, so to speak, because you could win the battle and lose the war. The upside is, if you're opposing those nominees, and he was referring to Miguel Estrada, who was one of the more controversial ones for the D.C. Circuit, you block them, and they were successful. The opposite of the converse, of course, is that when it's your turn and you have the power, you're going to get more opposition as well. I suspect President Obama's vote against Chief Justice Roberts is probably one he regrets if he had to do it over again. Because regardless of where he stood politically, and make no mistake, he stands to the right, Roberts's qualifications were so impeccable that a vote against him was probably a political vote. And so then you get Republicans then saying, well, you did that to us, we're going to do that to you. Now, that's not to say that's where the cycle started. There's examples on both sides going back. And of course, I left out one of the most notorious Supreme Court confirmation fights of all, which was Clarence Thomas. But that's kind of in a separate category because, of course, there were the sexual harassment allegations, and that's, I think, what really drove that. I think without that, even notwithstanding his conservative views, he would have sailed through. Once Anita Hill's accusations came out, I think that's what drove that. But actually, one interesting note, I don't know if I'm surprised if anybody would know this, but Estrada's wife is actually now the deputy head of the Supreme Court press office. So he at least has one hook in the Supreme Court, so to speak. Yeah?
Given that we had about 200 years of history before Bork, why didn't writings become as important before this?
That's a great question. I think technology and the ease of getting them probably is a factor. I think a greater awareness of the Supreme Court and also being at kind of a tipping point where people recognizing this particular nomination could shift the court one way or the other. I think those are factors. But as to why, I couldn't say for certain. But I would say going forward that, if you play out what I've been talking about to the full extent, whenever it is that Justice Kennedy steps down, I think then you're going to see quite a bit of maneuvering and a fight to end all fights, so to speak, especially if the court is divided the way it is today. Yeah, go ahead.
Could Congress pass a law that the Supreme Court had to televise its arguments? And if it, I don't know. And if it could, why haven't they?
They've talked about that. In fact, Arlen Specter, before he left the Senate, that was one of his big issues. He would constantly chide whoever the Chief Justice was, whether it be Roberts or Rehnquist before him. Annually, in case people don't know, the Chief Justice goes before the Congress to ask for money, so to speak, for pay raises for all of the judges across the federal spectrum. And in doing that, Specter invariably would bring up the televising of Supreme Court hearings. That would be an interesting question. Could they pass a law like that? They probably could. Now, could it be challenged in court? That probably could happen too. So that would be interesting to see. Some of the opposition says, well, you'll get a lot of grandstanding if the cases are televised. But I suspect that probably wouldn't be the case. Unlike, say, the O.J. case or some other notorious cases, you only have 30 minutes per side to make your point. So there's not a lot of time to be doing an end zone dance, so to speak, when you're up there. So I suspect it would be much like C-SPAN with the Senate if they were televised, and that'd probably be a good thing. So, yeah.
You were talking about Kagan's recusing herself.
Yes.
Senator Leahy has like a bill out that says that if a justice recuses themselves, a former living justice might. Do you think that, step in and actually fill in for that justice? Do you think that has any chance of actually passing? Or do you think that's just kind of...
I don't think it has any chance of passing. And the reason being, who steps in? I'm sure Justice O'Connor would be thrilled to step in. In fact, she in fact has stepped in on the First Circuit as a visiting judge in a number of cases. Don't know if you're aware of that.
So is Souter.
And Souter has as well, yeah. So a couple good examples of that. But I suspect, depending on who's filling in, that there'd be a lot of opposition to that. But the one other point with Kagan I would make is that, of course, this is a short-term situation. It's going to be an issue probably again next term, but after that, you're going to see fewer and fewer cases where she actually signed the brief as Solicitor General. So I saw one over there. Yeah.
Well, we often discuss how political persuasions affect the appointment and confirmation of justices, but to what extent do the judicial philosophies of the existing judges affect the public's judicial philosophy? So, in other words, does it go both ways? So, if the public has little pre-existing knowledge of the sitting justices, which, I mean, you even see on late-night talk shows, they say, the average person can't even name one justice. So if we don't really know a lot about, maybe how they got there, then does the public have a certain level of deference to their philosophy? So does that shape, does it go both ways?
To an extent. I mean, there is a lack of knowledge, and I think that ties in with this gentleman's point about the televising of the court. I think there'd be more knowledge if it were televised. Unfortunately, there's less. I suspect the public probably doesn't have a real good sense of where the justices stand on a lot of issues, as you note. And in fact, I should point out, many issues that come before the court aren't really big political issues at all. If you have some banking dispute, for instance, involving Bank of America, it's probably not a Democratic or Republican issue. I don't mean to say that every case is driven by political factors, but in terms of judicial philosophies, it's kind of a hard one to answer as to which one. It's like the chicken or the egg, so to speak. So, yeah, in the very back.
Isn't it true that one sign that justice might be leaving is if he or she hasn't hired law clerks for the coming term or a full complement of law clerks?
Absolutely. Yep, that is absolutely true. Justice Stevens, for instance, last term had only hired one. They typically hire up to 4. So that is a sign. But sometimes they hire the clerks and retire anyway. But yes, generally that can be a signal that they're stepping down. And haven't seen any evidence that Justice Ginsburg hasn't hired clerks for next year. So not meaning to suggest that she's leaving, because I don't have any knowledge of that. I just meant to say earlier that she could be the most likely candidate, taking into account her age, where she stands, and where we're at right now. So, yeah.
You said at the very beginning that most of the time the nominee is able to keep themselves from saying anything concrete during their confirmation hearing. And we were talking earlier about whether there's any way to make them state an opinion. I was just wondering if you think there's an effective way to do that, and if there is that a good thing or a bad thing?
Good question. Judge Bork, who I talked about earlier, he said quite a lot during his confirmation hearings when it wasn't going well to try to defend himself, and kind of only dug himself more into the muck, so to speak. So I think the lesson a lot of nominees have taken from that is not to say much of anything. But it's interesting because oftentimes what you get is people saying, well, I don't want to talk about that question because it could come up before the court. But you see a couple of examples, I think came up with Justice Sotomayor, where they answer a question and say, well, I'm going to answer it because this is settled law, so it's okay that I answer it. Well, it's hard sometimes to tell what's settled law to you and what's settled law to me. Things could change. So I suspect it's not going to change with nominees saying too much. I think it would be better if we knew more about where they stood. But my guess is that the vetting process is so extensive now that you could kind of assume that the overwhelming majority of the time, the person who's there is likely to be pretty close to where the president is, if nothing else, even if you don't know what they've written. So, any others before we, yeah?
They closed the front door, right? Did they, to the court, like the entrance, did they change the security system? Did I read that? They closed the front door?
That's been reopened.
Oh, it's been reopened?
Yes. Yeah, it was closed. You're right. You're
During
absolutely.
the time it was closed, was there a different mood, and what led them to reopen it?
That's a good question, and I have to say I don't know what led them to reopen it. I do know that I can tell you they were remodeling the court. So to be honest, they said security. It could have had as much to do with the fact of people walking around. The press room, for instance, for a couple of years was in a trailer. Fortunately, that's since moved back to inside the court. And you've had other offices that were moved around as well, including some of the justices' offices. So some of it was security, but I suspect some of it had to do simply with the remodeling of the court. So, yeah.
You briefly mentioned that Justice Ginsburg might retire after the suit. Is there any particular candidates we should look out for, or of name that are out there that might replace her if she does indeed go ahead and retire?
I would guess that you'll hear Diane Wood's name again. She's a Seventh Circuit judge who's fairly liberal. A lot more of her views are known than Kagan, but also that's a fairly conservative circuit, and all of her conservative colleagues have raved about dealing with her. So there was some thought that she'd be a good person to have on there with Justice Kennedy. So I suspect you'd hear her name. Oftentimes you tend to hear the names of the people who didn't make it the time before. For instance, Kagan was one of the runners-up when Sotomayor was picked. Alito was a runner-up when Roberts was picked. Sidney Thomas, who was a Ninth Circuit judge, is a name you could hear. And you could hear some politicians. I know President Obama had said, we don't want a Supreme Court where it's only judges. And certainly it hasn't always been that way in our history. William Howard Taft, former president, became Chief Justice. There's other examples I could name, but don't want to bore you. But the former governor of Michigan, Jennifer Granholm, could be a potential nominee. So there's people out there. One person who'd been mentioned, but frankly I think she's dropped off the radar screen a bit, is Janet Napolitano, because she's had some controversies as Homeland Security Chief. I think she'd be kind of a toxic nominee, but a couple of years ago, she was someone who was mentioned. Yeah?
I guess we'll have to be our last question.
I have a vague memory when I was a teenager that Abe Fortas was a Lyndon Johnson nominee. Was that true?
Yes.
And what was the issue around him as a nominee? Do you remember what that was?
Yes. There were some, and someone's free to jump in if I don't remember it correctly, but there were some rumblings about some land dealings that he had when he was in practice in Tennessee. Or you're shaking your head no.
No, Fortas?
Yes.
He took money from the Wilson Foundation in Florida, which was in bad odor, and to supplement his salary, and that was considered inappropriate, so he had to resign.
He was already on the court.
Yes, he was on the court. Thank you. Yeah, I thought it also had something to do with some somewhat shady land dealings as well, no? But
it was shady practices that he was accused of, which convinced him to withdraw.
Right.
That's my recollection.
Right. He was on the Supreme Court for 3 years.
And he would have been Johnson's choice for Chief Justice, which was part of the issue.
Right. That's right. In fact, actually, that was why you don't see these things in an election year, because that was 1968, and undoubtedly there would have been a lot of opposition. But thank you, everybody. Very enjoyed it.